and welcome to my channel. My name is Dwayne Kimball and I'm a United States Army veteran. Today I'm bringing you another educational video as it pertains to the VA disability compensation claims process. In today's video, I'm going to be discussing what is a duty to assist error. A lot of veterans are still confused, so today I'm going to break it down for you. But before we get into today's video, I want to challenge all veterans to submit that FOIA request to the Department of Veterans Affairs so they can obtain a copy of their VA claims file. I'm going to link the video that I did on what is a VA claims file and what is some of the evidence that you can find in it at the end of this video, okay? So, duty to assist errors. I'm still getting calls from veterans when they go through the high-level review process, and they'll say, Dwayne, the decision review officer told me that was a duty to assist error. And then they'll ask me, well, what was that error? And I'm like, well, you didn't ask the decision review officer when you had him on the phone, okay? So in today's video, I got a couple of slides for you, and I think it'll help you understand what is a duty to assist error and give you some examples, okay? So with that being said, let's go ahead and get into it. Slide number one. As you can see here in slide number one, there's the M21 reference as it pertains to the definition for duty to assist errors. Now, I want to point out where I received this information from. I went to the VA's website, the M21 reference manual, and I took this from the M21-5, which is the appeals and reviews. Normally, I share with you the M21-1, which is the adjudication procedures. So this M21 covers appeals and reviews, also known as what? High-level reviews, all right? So what is their definition? HLR, which is, we know, high-level review, may identify a deficiency in VA fulfilling its duty to assist the claimant in obtaining evidence relevant to the decision under review. Now, a DTA error is a failure during the process of the review decision, meaning the rating decision, the initial rating decision that you receive, to properly apply provisions of 38 CFR 1.59 for gathering evidence. And we're going to cover off parts of 38 CFR 3.159 in the next slide. These deficiencies include omitting development or failing to request certain examinations. Now, omitting development could be something as simple as you told them, hey, you got treatment from a private physician somewhere, and they fail to send you a medical form so they can, medical release form so they can go out and get those records, or fail to go out and look at progress reports at certain VA medical centers that that you sought treatment from, and then failing to request certain examinations. So let's just say, for example, you filed a claim for flat feet. On your entrance exam, it showed you had mild pes planus. During service, you sought treatment for bilateral foot pain. After service, you continued to seek treatment for bilateral foot pain. You claim pes planus, you submit that evidence showing current diagnosis, and they denied a claim saying, hey, we don't see this treatment in service, okay? So that would be failing to request a certain examination, because in the scenario I just gave you, they should have requested an examination based off of direct service connection, okay? So a lot of veterans, they jump right to the high-level review and they don't understand, well, was a duty to assist error even made when the rating specialist was adjudicating that claim, okay? So I think this is key, because when you get to the high-level review stage, you shouldn't, the DRO shouldn't have to tell you there was a duty to assist error. You should already know that. But if not, if they do start talking about duty to assist errors, then the next question is, well, Mr. DRO or Ms. DRO, what duty to assist error was made? Did they fail to give me an exam, or was it omitting certain development? Okay, now let's get into slide number two. Here in slide number two, this is the 38 CFR 3.159, Department of Veterans Affairs Assistance in Developing Claims. Now, This was a large CFR. It had a lot of information. So you have the number and the name of the 38 CFR. I couldn't fit all of it in one slide, but I took some pertinent information, some information that I thought that was pertinent to today's video, okay? So, Section C, VA's duty to assist claimants in obtaining evidence, okay? So they have to go out in certain situations and obtain certain evidence. So the first one, number one, obtaining records not in the custody of a federal department or agency. The claimant must cooperate fully with the VA's reasonable efforts to obtain relevant records from non-federal agencies or department custodians. Now, on the VA Form 21-5266Z, I believe it's in Section 17A, it asks, have you obtained treatment from anywhere? A lot of veterans put information in there. Yeah, I obtained evidence from this doctor or this doctor. When you put, you received treatment from anywhere, especially a private doctor, you just add about anywhere between 3 to 6 months onto your claim. Because then the VA is going to send you a medical release form. And that's going to put your claim on hold for 30 days. You sign it, send it back, they get it. Let's say in 45 days they take action, then they send it to the doctor. They ask another 30 days. The doctor doesn't respond. They may send another letter to the doctor if the doctor didn't respond. And then if the doctor doesn't respond, that's another 30 days elapsed. And then they're going to send you a letter saying, hey, the doctor didn't respond. That's another 30 days. And then in that letter, they're going to tell you it's your ultimate responsibility to get the records. So why not go get the records anyway before you even submit the claim? Okay, makes sense. Now, if you leave this, that section blank and you submit your documents, your claim should move to the next stage, all right? Number two, obtaining records in the custody of a federal department or agency. So let's just take an example, vet center, a VA vet center. That's a federal agency, okay? But if you note that you receive treatment from a vet center, they have to go out and ask that vet center for those records. A lot of VA medical records, I think that are older than 2005, may not be in the VA healthcare system's electronic progress notes files, okay? So they may have to go out to that location. If you say, hey, I got treatment at the VA, Albuquerque VMAC in 1990. So they have to go out to that VMAC and wait on those records to come back. And let me tell you, the release of information offices are really slow, which means that adds time on to the VA making a decision on your claim, all right? Obtaining records in compensation claims, providing medical examinations, or obtaining medical opinions. So like in the last slide, one of those is not requesting VA exams. So again, in that scenario that I gave you, were you treated in service? Is there the current diagnosis? Then if so, that's 2 of the 3 requirements for direct service connection where you should have obtained an exam, all right? Subpart D, circumstances where VA will refrain from or discontinue providing assistance, okay? They're not just going to take the next 10 or 15 years trying to get some records, all right? So the claimant's ineligibility for the benefits sought because of lack of qualifying service, lack of veteran status, or lack of legal eligibility, all right? So let's just say the veteran has a dishonorable discharge, all right? 1 period of service, dishonorable discharge. They'll do a character of discharge, go out and do some additional development for it, and then they make a determination. The vet continues to come in, say, hey, what about this? What about that? And they may continue to do some research, but when they find that, hey, we've done what we've done, and in this scenario, then the vet has to go to their department that they serve and possibly try and get an upgrade, okay? And another example is if a private doctor's office is closed. There's no way that the VA can go out and get those records. The office, I've talked to veterans, they say, hey, I went to the emergency room at this hospital and the hospital is no longer there. They tore it down, they put up a parking garage. So how is the VA able to go out and get those records? That building is no longer there. Those records more likely have been destroyed, all right? Number two, claims that are inherently incredible or clearly lack merit, all right? And an application requesting a benefit to which the claimant is not entitled as a matter of law. Then it says duty to notify claimant of inability to obtain records. So again, in that one of those scenarios I gave you, when you go out to the doctor's office, and when they go out to the doctor's office and try to get some records, and the doctor doesn't respond, okay, then they have a duty to notify you of inability to obtain records because that doctor didn't send them back. Or if they go out to a VMAC and the veteran says, hey, I received treatment at this particular VMAC back in 1975, they may not still have those records, okay? It's a possibility they could, but they may not. But if they don't, then VA has to notify you on that, okay? So I hope that cleared up duty to assist. Just because there's a duty to assist error does not mean you're still going to get service connected. The VA, by law, has to give you due process. Part of that process is duty to assist, whether in this instance, going out and getting evidence, making sure they've done all the development to get all the correct evidence to adjudicate your claim. A lot of veterans think, oh, they did a duty to assist error, so that means I'm going to get service connected. That doesn't mean automatic service connected. Now, they could go out and get these records and you could get service connected, but it doesn't mean that it's automatic. Second, when you're on the phone with that decision review officer and they bring up duty to assist, ask them, what is the duty to assist error? What is the error that was committed by the RVSR? Okay? Ask that question. That is the time to ask that specific question. All right? Now, if they don't bring up a duty to assist, you have to think, how am I claiming? You know, what am I claiming? How am I claiming? If you're claiming a direct service connection, you need three elements: current diagnosis, a link in service, meaning you have to have been treated, complained, you have to have a treatment, complaint, diagnosis, injury, or disease. If you meet one of those, then they should schedule a C&P exam to get a nexus, okay? So in that duty to assist error examples, one of them could mean, hey, they didn't go out and give you an exam to obtain a medical opinion. So you should be bringing that up on a high-level review and formal conference if they denied it and you actually appealed it, okay? So I hope you find this video informational and educational. As always, make sure you like, subscribe, hit that notification button, and don't forget to share this video with your fellow veterans. Thank you.